We have lots of colleagues already. So colleagues, I'll just take your permission. We normally record these sessions. So um, this would record it just in case somebody wants to listen to it in the future. Welcome everyone to today's webinar on protecting the arbitral process and practical thoughts on how to deal with dilatory tactics. Our speakers are here, and in a minute I'll introduce you to them. But could I just start with ground rules to say, please, anyone who's not speaking, anyone other than our speakers, should please mute, please. If you're not speaking, just so that we can hear ourselves, please go mute. Only our speakers are permitted to leave their mics open. Thank you. Second, we'll just do a quick safety brief. This call, we are having it virtually, but we would beg of you, if you're driving, don't take this call, except you're able to park, find somewhere safe to park, and then after the call, you can continue driving. Please be situationally aware where you are. So if you're in a location, for example, and you be sure that you can hear the fire alarm if you were to go up, right? And if that happens, please leave the call and follow the safety precautions of your respective locations. If you have questions, please send them via chat. We'll be able to look at them when we get to Q&A. This there's a record of the attendance of those that have joined. So you don't necessarily need to introduce yourself via chat to the room, because what that then does is to kind of get in the way of messages that are meant to be questions for our speakers subsequently. So without further ado, I'll just get into introducing our speakers. I know you've gotten our emails, you already know them. But just to run through it again, and we will start with we are gentlemen, and in Nigeria we say we're all gentlemen in skirts, and we are all gentlemen, whether you're in skirts or you're in trousers. So let me start with the Leonard Silk, Mrs. Adedoyin Rosebible, SAN. She is a former chair of of the Chartered Institute of Arbitrators. She has over 40 years of experience in the arbitration field. I'm sure many of us know her, and I'm sure some of us weren't born when she started practicing arbitration. She is an approved tutor of the Chartered Institute of Arbitrators. So if you've ever done a course with the Chartered Institute of Arbitration, you know Ms. Rodviva SAN is one of the tutors that you know teach those courses. And she's also an author. She has a book on the subject. So overall, she's very well grounded, and I am personally looking to tap from her depth of knowledge in the course of our conversation. Um, I also go on to the second person, which is someone for me that's home, Mrs. Enobong Ozo, an accredited mediator of the Center for Effective Dispute Resolution. She is also, since 2022, a Nigerian representative to the ICC, the International
You're
Chamber of
welcome.
Commerce Commission on Arbitration and ADR. Currently, she's the managing counsel litigation in Renaissance Africa Energy Company Limited. Renaissance is the successor company to the Shell Petroleum Development Company of Nigeria
I
Limited.
don't know.
Sorry, I'm
Thank
still,
you.
please, can you, everyone just go mute? I'm still getting a lot of background noises and feedback. Please, could I just ask that we go mute? Okay, thank you. Um, and last but not least, I have Mr. David Njoroge, who's a senior partner and head of dispute resolution at Njuguna, and Njuguna is a Kenyan boutique law firm. He's joining us all the way from Nairobi, and we're delighted to have him here. He also is an approved CRM tutor, and he's a member, this I found interesting, he's a member of the Kenya National Steering Committee for Formulation of Alternative Dispute Resolution, and he's been in the arbitration field for decades. So these three persons are our distinguished speakers for the day. And in the next 55 minutes or so, I will be having conversation with them on our topic, and hopefully we'll learn from it. I just want to acknowledge time may not permit me to give each of them time to, to speak to us, but I want to acknowledge the support from our parent, which is the CRM itself. The chair, I don't know if she's on this call, but Miss Olushola Adebomire is the current chair of the Chartered Institute of Arbitrators. She's been very helpful in our activities. I don't know if Reverend Dr. Belusi is on the call as well, the secretary, and you have folks in the admin section of the day-to-day running of the CRB. I want to thank all of them. Can't start mentioning all the names, but we are so grateful. And I also acknowledge the committee chair, Dr. Nike Esho, who's been leading this committee from its founding, from its inauguration in March. Thank you all. Welcome to our speakers. Thank you so much, Mrs. Roosevelt SAN. Welcome. Just say hello so the audience can know you're here too. Hello? Can you hear me, ma'am? If we could unmute Ms. Dilatory, please. Hello? Sorry, one second. Hello. If sorry, I'm just trying to unmute our speakers. I think there's a bit of technical
I will do that.
challenge.
I will do that
Okay,
right now.
thank you. Thank you so much, Chair. I I just want to hear the voices so we can get started.
Hi, Victor. Can you hear me?
Yes, I can. Yes, I can hear you now.
Yes,
I
we've been
can hear you.
unmuted.
Okay. Oh, okay. Excellent. Thank you so much. So I was just going to say, so that you just say hi to everyone. So I started with, but since I can see you, Ms. Enobangozo, so just to say hi and welcome to our session. I don't know if you want to say hi to the audience just before we start. I just want to be sure that they also can hear you. So
Okay, I think Miss Ozo is saying hello. I think Miss Ozo is saying hello.
okay. Oh, please, everyone else other than the speaker, please just mute. Please. Hello. Hello, our speakers, you can unmute yourself. I think they muted everyone, so it's just for three of us, the three speakers and the moderator, to unmute so that we can get started. Thank you.
Okay. I can now speak. Mr. Victor.
Okay. Yes.
I'm
yes.
okay.
Okay.
I'm okay now.
Okay. All right. All right.
So
Thank you, ma'am.
We're just to say hello. So I'm saying hello very briefly. I'm glad to be here. Thank you for having me.
Thank you so much, ma'am. Please just remain on mute because we will then start our questions. Please, could I also ask Ms. Ozo, please just unmute and speak, and Mr. Njoroge as well, just so that all your three mics are open and we can get started.
Yes, good afternoon from Nairobi. It's a pleasure to be here, and I'm looking forward to a fruitful engagement. Thank you.
Thank you. Thank you so much. Excellent. Ms. Sozo, please. Hello, Ms. Sozo.
Okay, now it's unmuted again. We'll leave it open. Thank you.
Leave it open, yes, please. Thank you.
Yeah.
Okay, thank you so much. And apologies that the technical issues have taken us a bit, but we'll just dive right into it. Today we are discussing dilatory tactics in arbitration and how to manage it. So let me start off by just, for the benefit of our audience, asking, what do we understand? When we refer to dilatory tactics, what are we talking about? I'll be switching the order, but let me just start again. Keeping the principle of ladies first and seniority at the bar. And let me perhaps start with the Leonard to say, can you just give us your view on dilatory conduct in arbitration or dilatory tactics? What that's all about?
Okay, thank you very much. I believe when we say dilatory tactics in arbitration, we are meaning it in a negative manner. It's any conduct by a party that's with intent of deliberately distracting, disturbing, or prolonging the proceedings, or maybe not even allowing the proceedings to go on. It's aimed at frustrating the efficient conduct of the arbitration proceedings, and it could be done in various ways. You could have a party who refuses to come to meetings. You can have a party who refuses to comply with the procedural orders of the tribunal. You can have a party who brings in excessive document production. You can have a party who brings in frivolous jurisdictional objections. And there are so many ways. Parallel court proceedings at the same time as the arbitration is going on. This is just to destabilize the proceedings, destabilize the parties, and just hopefully bring the proceedings to a halt. Thank you.
Thank you so much. That was very succinct and concise. So I'll just test with okay, let me come to Ms. Anjonoge. Do you have anything to add, any dimension that's not already covered?
Thank you, Victor. I truly agree with my senior in her elucidation of what dilatory tactics are. But just to add on that, is to state that they actually border range from unethical conduct, but legal, through to even criminal behavior that can be used to basically distract the arbitral process. And also, in a nutshell, it is more of a delay strategy rather than a necessity. That is what I would add on to that. Thank you.
Oh, thank you so much. So it also has ethical implications for those who embark on it. Okay, thank you. Last but not least, Ms. Sozo, I mean, you are in-house counsel. So do you see it, is there, an angle that you also see dilatory conduct in addition to
Thank
what
you, Victor.
others have
Yes,
said?
in addition to what my learned co-speakers have said, I just term it Jankara practice in Nigerian parlance. People just bringing in everything that we do not like about litigation in our own jurisdiction here, where things are delayed, bringing it all into arbitration, which, the part of the main attractions for going for arbitration is speed. And so they come in with all these actions and inactions, as the learned SAN has listed, to delay and annoy the other party. And for me, what I always see in it is that they're trying to push for a settlement by trying to frustrate the process from going forward, in a speedy or in line with the timetable that had been agreed. So that's been my own experience on dilatory practices. Hi,
Thank you so much. I like the uniquely Nigerian description that you use, Jankara practice in arbitration. So since I have you, I'll just hold on to you a little bit more to then ask, as in-house counsel in your role. I mean, you've been, for as long as I've known you, you've been doing disputes from the in-house as in-house counsel. So are you particularly concerned when you see what seems to be dilatory tactics?
Yes, very concerned, because for us, disputes are actually a good thing, because it means that people are not, when people take their disputes to arbitration and the likes, or whatever dispute resolution forum, they're not taking the laws into their hands. So they're taking it to some independent third parties to help us determine it. So it's a good thing. And we want it, determined as fairly and quickly as possible. Because many a times, these claims, when they are filed, a whole lot of money is being claimed. So it's there on your books, and the business folks are very concerned about, the reputational impact, even the effect on lenders and investors, seeing this sort of a high claims being filed against the company. So you don't want it to be there for so long. And when we go to arbitration, we try to assure that it's going to be a more robust process. It will get through as quickly as possible. But when these dilatory tactics are then deployed by the other side, it just makes even the business begins to question the judicial system and the efficacy of things. So it puts us in a difficult situation with our business folks as to whether they should really trust this process to deliver the outcome that they expect at the end of the day. And then another thing is that whilst this is going on, whatever transaction or project was in issue, most times what I've seen is that it gets held up because someone would have already gone to court, gotten an injunction, restrained something from going on, and they're not bothering about what they do know. I always feel it's deliberate. The knock-on effect. The project was supposed to be concluded. People who are down the chain supposed to be buying the products or whatever. All those things are, the knock-on effect on the business is there, and you are trying to contend with it. The business is trying to manage it, and they keep coming back to you. So when is this case going to end? When is this arbitration moving on? And, so it also affects our business and commercial interest when this dilatory practices or tactics delay things in arbitration. So it gives us a lot of concern and pressure.
Thank you. And I can confirm I've had several folks in-house say that as well. So for a different perspective, just this same question, but let me ask Mr. Joroge now. Mr. Joroge, you are the vice chair of CRI Kenya. So you're a bit involved in an arbitral institute from the arbitral institution point of view, and you're also a practitioner. Do you also share in are there concerns from those lenses that you see with dilatory tactics?
Yes, thank you, Victor, for the question. Let me start as a practitioner. As a practitioner, an arbitrator, and an ADR practitioner, dilatory tactics really affect the process. And one of the major ones that outstands is the issue of costs. Arbitration has been largely criticized of late due to the ever-rising costs. And most of these costs, you'll find that they are spiraling up because of such dilatory tactics. Because if you let the arbitral process follow its due process without any of the dilatory tactics, then you can be sure that it will be cost effective. But these dilatory tactics bring about delays, which bring about rise of costs, and hence a lot of reputational damage to the institution that is levying the arbitral process. Again, also from an institutional perspective, of course, we project ourselves and promote as a premier institution, as CIAB Kenya, as the premier institution for dispute settlements. So whenever arbitration comes to us and we make the appointments, and then the clients out there and the parties feel that their disputes are not being resolved. Remember, they chose the ADR process for its cost-effective and also its nature in terms of expediting the resolution. So whenever these dilatory tactics come, they truly, truly damage the reputation of the institution and the trust that these clients may have on the institution. So thereby diluting entirely. And this even goes down to the entire country, that the country can be seen as though it is not a safe seat for international arbitration, which can deter even foreign investors from coming. So as a practitioner, there's a big challenge in terms of dealing with this because it increases the cost. As an institution, it damages the safeness of the seat, the trust, and basically the confidence that the parties had when they come to you to appoint arbitrator and looking forward to an expedited resolution of their dispute. Thank you, Victor.
Thank you so much. I think that's really clear. So just to complete this 3D, so we've seen in-house counsel point of view, we have listened to practitioner and arbitral institution point of view. So I then come to the learned self. We know you in this field. You've been you're a seasoned arbitrator. From that point of view, as an arbitrator, do you also see concerns, see reasons to be concerned when dilatory tactics are in play?
Thank you very much. I do see serious reasons to be concerned. First of all, as an arbitrator, as a party, we have an obligation. And if you look at the regulatory framework for arbitration, it emphasizes expeditious dispute resolution. Under the new AMA 2023, it talks about the objective of arbitration is to promote fair resolution of disputes by an impartial tribunal and without unnecessary delay and expense. It's also repeated in the rules. The same thing is repeated in the English Arbitration Act. It's repeated in June Citral. So we all have an obligation to make sure that the proceedings are conducted expeditiously and without unnecessary delay and expense. When people or parties are not ready to cooperate with each other, it results in problems. And there's no problems that cannot be solved where there's cooperation. For instance, if a witness is not genuinely available, you can have that witness by video conferencing. You can do that. There's so many ways you can sort out issues that could arise. For instance, if the two parties are cooperating, instead of wasting your time on calling witnesses and spending money you really don't have to spend, you can agree on a document-only procedure, because we all know that arbitration is party autonomy. The arbitrator need only take a decision if the parties cannot come to an agreement. So if the parties agree, oh, let's have documents only. You know, this is a simple dispute. It's really the interpretation of this contract. Why don't we have it documents only? And then another thing is costs. If you agree to have a meeting, a party now tells you 2 days before or 3 days before that is not able to come for that meeting. Meanwhile, the arbitrator has made arrangements for the hearing of the hall. He's made arrangements for the refreshment. He's made arrangements, he or she has made arrangements for the transcriber. So you find costs also being thrown away. And then they go to the court. I've seen cases where the disgruntled party will even start serving notices on an arbitrator, telling them about a challenge proceeding going on. I mean, what's the arbitrator's concern with that? So we find that parties play all kinds of games, which really is not ideal. When I have my proceedings, I can always identify lawyers that are litigation lawyers from the onset because I see their tactics. I can always, and it's not good. It's not good for the procedure. It's not good for the country. We all remember the IPCO case where it was stated in that judgment that the wheel of justice grinds very slowly in Nigeria. And yet we say we want investments. We say we want Nigeria to be a seat of arbitration. I mean, we all have a role to play. And then particularly for lawyers, I've had many occasions when I've had to write in my letters, because I can be very strict, because I know you have to know your law and you know your rules, then you have to know how to apply them. I've had occasion to even write to them and remind them of the rules of professional conduct at the bar. What is your role as a lawyer? It's not to come and take a side of a party. It's to assist the tribunal. Even the rules of professional conduct, legal practitioners' rules, talks about how counsel must accord judges and arbitral tribunals due respect. But in this guise of some lawyers that I think have forgotten their rules of professional conduct, they come to tribunals, they don't even mind being rude to arbitrators, all in the guise of assisting their parties in the most inappropriate manner. So dilatory tactics is really a problem, and we really should desist from it. It's not doing us any good. It's not doing our country any good. It's not doing our profession any good. I don't know how many of us are, okay, we must all be lawyers, because I think this is part of fulfilling we're not all lawyers. I can see you, Zoe, smiling. So we should really remember the rules of professional conduct at the bar. Thank you very much. I hope I've not spoken too much.
No, you've not. I don't know about that, but I like the passion, because you know, that's the whole essence of this. So that for those who don't understand, hearing from all the three views how it kind of does us bad, you know, it helps to drive the message home. But I will stay a bit more with you, the Leonard Silk, today that I have that privilege without having to pay a big bill, to ask if you could, I mean, I know there's so many, but just to practicalize this, especially for those who maybe are not very involved in arbitration, if you could just tell us give us an example of where you've seen this play out, and maybe whether it was resolved or how it was resolved, or whether it's frustrated the whole thing, just like a war story on where dilatory tactics have been in play.
Okay, I'll give you one example that involved a variety of different tactics. First of all, even the appointment. I was appointed by an appointing authority. That, first of all, shows that the parties could not even cooperate on the appointment. At times, it's for genuine reasons. At times, it's not. Anyway, because they couldn't agree the arbitrator, I was appointed by a judicial person. You know, I have to be careful of the confidentiality provision. After I was appointed, the respondent now brought an application for further and better particulars. That can also be a dilatory tactic. The claimants objected and said, these particulars, they have nothing, they're not relevant to the dispute, it's inappropriate to be asking for this. And then to fulfill my own mandate, I asked them to submit like a reference schedule. The respondent should tell me why he wants those documents. Claimant should say why he doesn't feel the documents are necessary for me to be able to arrive at a decision. An order went out to the parties for this form to be filled. The respondent refused to fill it. After one or two instances, and I had to give an unless order, they didn't fill it. So eventually, I dismissed that application. After that, the next thing they did was, I'm trying to remember all the steps because there were quite a number of steps. They now asked, they now actually challenged me. We had a procedural meeting, right? And during that meeting, I made a statement, right? Which was not unfair in any way. I don't want to say the statement is to preserve the confidentiality. And the next thing was that the respondents accused me of having a grouse. I mean, what business will I have to have a grouse against a party? They said I had a grouse against it. And it had come to seriously doubt my impartiality and independence in the matter, and that I should excuse myself. I looked at what they said I did. Luckily, that's another tip we should always have. I always have my transcripts, and I have the video recording of my transcripts. So I reviewed everything. I knew it was just part of their game. And I delivered a ruling. And in my ruling, I'll be very precise. I'll refer to what they said I said and pass it to them. And I gave my decision that there was no impartiality or fairness rendered on that. So that went on. Then the next thing they did was challenge my jurisdiction. The claimant had included a particular claim in its claim. They said I had no jurisdiction over it and that I should not look at that document. Now, that document was part of the documents that formed part of the papers that were laid before me. And in my own considered and fair view, I felt that I could not at that stage make a decision on whether that document should be included or not. And that therefore, I'll make my decision upon hearing the case on its merits, which I am allowed to under the provisions of the relevant law. That was another ground for challenging me. So after that, the next thing was they rushed off to the Federal High Court, started copying me papers that filed before the Federal High Court. And I continued because until I have an order from the court telling me to stop, I'm not going to stop. The court now said, I think the court now said they wanted to take the application. And I think at some stage, the court said I should stop. Then I stopped. The judge looked at all the things, looked the transcripts. I didn't go to court anyway, because I wouldn't. Looked at the transcripts. I don't know whether they listened to the tape. And the judge rendered a decision that all the allegations made against me were all framed up, The words of the judge were something along those lines, which also emphasizes the need for our judges to understand the arbitration process, that they were all framed up and dismissed their application, that I recused myself and all that. And then they had to come back to me. I think eventually, because I then had to write a letter complaining to the party about his lawyer's conduct that was not abiding with the rules of professional conduct at the bar in relation to the way he was trying to interact with the tribunal, which of course was all in a bid to frustrate me from doing the work I was appointed to do. Eventually, that counsel was changed. And I believe it was another counsel that now completed the matter and were able to finalize that proceedings and an award was issued. So that is just one of the stories I have. I have another one, but I don't want to manipulate time. So I'll leave it at that for now.
Thank you so much. And this story has a lot of examples of dilatory tactics. So same thing I asked you, I'll also test with the other speakers. Mr. Njonoge, some of us haven't been to Nairobi, we will soon, but if there are home stories, of the experience with dilatory tactics you could share with us, we'd welcome that as well.
Yes, thank you. And Victor, I welcome you all to Nairobi very soon. In terms of my experience, there can be those dilatory tactics that are as shouting as my senior has just told us of that story. Yet then there can be dilatory tactics that can be very silent. And if as an arbitrator, you do not pick them out, they can lead you actually to even challenge to your decision. So I had an experience whereby they start right from appointment. From appointment of by arbitration, they challenged and they said they needed, though the arbitration clause did not talk about any industry specific, once I was appointed by the institute, then they started challenging that they needed an industry favorable arbitrator. When I reviewed the contracts, I gave the other party the chance to respond. Then I told them to put a formal application. They did, and clearly there was nowhere. And the other party, the respondent, was the claimant was okay because there was no agreement in terms of an industry specific arbitrator. So once we did that and I rendered the decision, they went mute. We proceeded. What I would like to advise as a tribunal, as an arbitrator, always have your record very, very in good order. Always document everything because it can come back to bite on you. Also, all the order for directions I was giving, all the notices I was giving, and the correspondence, always ensure that you serve the non-participatory party. So we proceeded and proceeded. Of course, there is that option, even in the in situ law model, and also in our local arbitration act that allows for ex parte proceedings. But as arbitrators, we are very slow to proceed to that. But when I set up now the date for hearing, just before that, they came back. And now they sought time to comply and all that. So we lost quite a bit of time. And this is a silent dilatory tactic that can be used of non-participatory of a party until the stage that they think now things are moving fast. Then they will come and now draw back the entire process, because you have to again accommodate them and give them time to put in their responses and prosecute their cases. So dilatory tactics can be very salient. They can also be very open, as my senior has told us. So as an arbitrator, you have to be very vigilant and always read even the body language, and even in silence, you are able to pick out when there is a dilatory tactic. Thank you.
Thank you so much. Thank you so much. So let me just complete this cycle, because from here we are going to segue to dealing with all this from, as you are all speaking, I'm picking out the examples that we'll now drill down into and talk about how to adopt countermeasures. But let me check with Ms. Sozo. Again, from an in-house counsel point of view, have you faced dilatory conduct? Do you have stories or experience to share about that?
Oh yes, a lot. But I'll just zero in on I think the last one.
Okay.
So in this particular one, we had a matter that involved two separate agreements that are related, and parties had entered into this. I think it concerned a debt, calling in a debt, and I think a demand letter was given to call in that debt, and the other party now rushed to the Nigerian courts and filed for arbitration, filed a court case and got an injunction to restrain that. After parties then tried to settle, I think it took a couple of months or over a year, couldn't settle. The other side now decided that let's go to arbitration, because that's the proper forum provided for in both agreements, and went and filed for arbitration, and then also went ahead, because it was in the UK, and got an anti-suit injunction to stop this court case in Nigeria, so that we focus on the arbitration and resolve things. So from the beginning, it was an issue, even trying to decide on the panel for the arbitral panel. I think the first one was constituted. Constituting the second one, there was an application to consolidate both arbitrations, which was resisted. Lots of delay, excessively long time to file papers or agree to do things. And then when awards were issued, I think every award has been challenged or was challenged, the partial awards along the way. So there was a ruling on jurisdiction, a ruling on consolidation, a ruling on cost. Every aspect of it was challenged in the English courts, because that was the seat of the arbitration. Meanwhile, in Nigeria, the case that was initially filed, was appealed to the Court of Appeal, still trying to insist that this matter should not be here, it should go to arbitration. An effort was even made there at the Court of Appeal for an anti-arbitration injunction, which thankfully, I think it was after this new Arbitration Act had come into force, the Court of Appeal judges refused it and said they should go on. So I think for me, it was the challenging everything at every turn that was the main issue. And part of the challenge also included the partiality of the impartiality of one of the arbitrators appointed by the claimant side, which the English High Court actually ruled in favor of the respondents, to say that indeed, given the frequency of the way that particular arbitrator had acted in matters concerning claimant counsel, or with claimant's counsel, something like that, that, you know, if one could, an innocent third party could say, okay, maybe there could be partiality along the way. So that was, the arbitrator was changed, a new one appointed. And when the new arbitrator was appointed, again, the whole awards that had changed again, that, okay, now we have a new arbitrator things. And if you look at it, there were 3 arbitrators and they all had agreed on this. So even if this new one coming in disagreed, it wouldn't change the outcome of those previous awards and decisions that were lasted 5 years. At the end of the day, I think something which I saw counsel do or advise was a preliminary issues hearing. And I think that is really what turned things in that arbitration to move along. Looked at the paper, so it wasn't like a bifurcation. It wasn't like in the nature of a PO to say you don't have jurisdiction. It was to say, look at the fact. If you look at them at this stage, you see that 85% of the disputes can be resolved on paper. You know, of course, there was a fight, oh no, we need witnesses, we need a hearing to be able to, but they said, look, if we go through this, 85% of this thing is out of the way. We can then concentrate on the ones that really need witnesses and all that and get to it. Some other thing I wanted to point out, raise at this is that as this was going on, we had to point out that, because I'd had a previous experience with city engineering, to point out that, look, the way we are going, this arbitration will end, we'll get an award, and to use it in Nigeria because we caught up with this city engineering decision. So we had to raise it, going. So we had to raise it and say to the tribunal, the timetable has to be agreed. We have to conclude this arbitration before, and they then said, oh, they would waive it, even to frame the agreement to say that we will not raise the city engineering or whatever limitation when the awards are out. Took a while to frame and everything. So, but anyway, at the end of the day, it was all done, and I understand even the final award has been challenged again in the Nigerian court. So 5 years, it's just equivalent to being in the state high court or federal high court in Nigeria, which is not what one expects when you go to arbitration. But that was the experience there.
Thank you so much. It's an interesting one, because in the course of explaining it, you have touched on something that I was going to ask this tribunal later, but I might as well ask now. So you've touched on city engineering case, which, and I hope you all will forgive me, but I would go to the Leonard Silk. I will flow from the Leonard Silk so she can give us, for those who don't know, what that case was about, and then tell us if anything has changed under current law. Leonard Silk. So, and after that, I would check with Stanjonoge if there is an equivalent, position in Kenya, just for our own learning purposes. So Leonard Silk, city engineering case. What are your thoughts on it? Because it seems to be the incentive, or at least it used to be the incentive for dilatory conduct.
Okay, thank you so much. Indeed, when that case was decided, there was a lot of outcry, including within the arbitration community and outside the community, because essentially what that decision was that time spent in arbitration does not stop the limitation clock from ticking. So obviously, that's a huge incentive for people who want to engage in dilatory tactics, because they know that the longer they keep that arbitration proceedings on, eventually at the end of the day, their actions will end up depriving the successful claimant or successful counterclaimant the fruits of the fruits of the judgment or the fruits of the award. But luckily, with the new Arbitration and Mediation Act, the situation has changed. It has corrected it. If you look at Section 34(2) of the new Act, it expressly states that the period between the commencement of arbitration and the date of the award or termination of the proceedings shall be excluded in computing the limitation period prescribed for the proceedings. That means that if the carry on with their dilatory tactics, all that time that they spent delaying the proceedings is not going to count when calculating the time when the action becomes statute barred, which is really great. So time spent in arbitration no longer counts against the party for limitation purposes. Therefore, dilatory parties can no longer exploit what are called the loophole in the law to achieve their objective. I don't know whether that is enough. Or
very, very concise.
simple.
Yes, yes. It couldn't be more, clearer. And I know if there are any follow-up questions, you in Q&A who would get those questions.
Yes.
So Mr. Njonage, just checking. Did you have such a position under Kenyan law?
Yes, thank you. I checked out that case of city engineering, and having such a decision would really damage the safety of arbitration and the considerable efforts that have been put in ADR towards having ADR and arbitration as one of the options of alternative to court. In Kenya, we also do have a similar provision under the Limitations of Actions Act, which state that the limitation is also applicable to arbitration matters. However, this has been interpreted in court in a very favorable manner. And I must commend our judiciary in terms of being very proactive. And one of the great things that we are proud of in Kenya is that the judiciary, we have a very good collaboration between the judiciary and the Chartered Institute of Arbitrators Kenya branch. And we do a lot of capacity building and training to the judicial officers. And when this question was put in the case of Peter Ouma Onyango versus Carlson, in 2021, the court stated clearly that issues to do with limitations of actions should be dealt with to exclude the time whereby the arbitration had started to the time of its conclusion. So with that authority, it is settled law that the issues of limitation do not affect the time that the arbitration takes place, because otherwise this would claw back a lot of gains, because then parties would not see the reason why they should put arbitration clauses. If you put arbitration clauses, then dilatory tactics come in, it end up taking away the 6-year period of action, then it can extinguish your claim. So basically, we are a proactive jurisdiction in terms of being a safe seat. And with that, we now have it firmly that the time the arbitration takes, it will be excluded from the limitation of actions. Thank you.
Thank you so much. Thank you. So I'll just check. I think hopefully this gives some comfort. For in-house folks who are dealing with dilatory tactics. But just to move along, because I'm mindful of time now. So from all that we've spoken, I'm not going to be asking specifics, which I know most of the folks in our audience want to hear. So I have been able to deduce some of the common dilatory conduct, outright failure to participate, perennial filing of frivolous applications, court gambit. So if for the next 10 to 15 minutes, if we could just take them one after the other. So let's start with outright failure. So context, there are people, like the letter also hinted, who they just won't appear in arbitration. For some reason, they see it as a way of frustrating the thing. And others, when that happened, I have seen a case where a counterparty refused to appear in arbitration. And then the claimant runs back to court to say, I started arbitration, they didn't come, so I'm now coming back to litigation. So I express no view as to whether that's the right thing to do. That's why I have our speakers. But that's just to say some people actually see it as a tactic. Now, how do you deal with that? Again, let me start slightly from in-house counsel to say, if you have a counterparty that you're in arbitration and the person is not responding, as in-house counsel, what would you advise that the in-house counsel starts to do, maybe with a view to helping the practitioner? So I'm coming to the source with that question. Hello, can you still hear me? Hello?
Yes, we can hear you, Victor.
Okay. I think
But she's not, is it?
Yeah, it appears she's having technical. So
I can't see her.
okay, so let's just go. So let us see if you can take it on. Maybe when she joins, we can pick up from there. But how do you do with a party who refuses to participate? And what's the practical tip?
Yeah. If a party refuses to participate, it depends at what stage. Now, it's everything. You have to start looking at everything from the time that arbitration agreement was entered into. If it's with participation regarding the appointment, then I'd have expected that clause to have included a default appointment procedure that if the parties cannot agree that either an institution, it used to be the courts they used to include, but now a lot of people are including the institutions. And we also have our Nigerian institutions, we have the foreign institutions that can make that appointment. Now, if it's during the process, they refuse to come, that's another technique. And you have the laws that allow you to use it. So you have to know your laws and use it. Because under the laws, under UNCTRAL, under AMA 2023, under the international arbitration rules, an arbitrator can go on in default of a party's appointment, in default of the party's participation, as long as you make sure you inform that party, you give the party adequate notice of any meeting. I mean, personally, I won't use that power the first time if they don't come. I'll give them benefit of the doubt. But like if they don't come the second time, I'm issuing an unless order. Unless you appear, the proceedings is going on. And most times you find that at that stage, they come.
Sure.
Unless they found another ingenious way of delaying the proceedings. But use that default appointment procedure. And then you also have your costs mechanisms you can use. You can remind them that the arbitration is XYZ. If they don't come on that day, they also stand the risk of costs being awarded against them, irrespective of the outcome of the proceedings. So the laws are there to help us. There are many soft laws we can use. If you are doing an ICC arbitration, you can go to the ICC techniques on managing costs in arbitration. You also have the, if you go to CIAB website as well, there are also various guidelines. I use them, I go there. Nobody's a reservoir of knowledge, and you have to keep on updating yourself. And many of these institutions, they work very hard in updating their guidelines. So you can go there. There's the CIAB guidelines, I think it's guideline 6 on managing arbitrations and procedural orders. There's even a CIAB guideline on parties' non-participation in arbitration proceedings, which tells you the steps you have to take before you use your default continuation process, ensuring that all the parties are notified. Make sure it's even documented. I know one of my colleagues have mentioned the importance of documentation. Make sure they sign that they received that notice. Make sure that the non-participating party does not have a valid excuse. That's why you can't just jump the gun. What if that party lost his father? Maybe the main counsel lost his father that morning. So you have to still give them the benefit of the doubt,
Yeah.
And make sure they are given fair opportunity. The Arbitration Act used to say full opportunity, but I believe that has been changed to fair opportunity to present their case. If you don't do that, it's a ground for setting aside. So we have a number of all those techniques that we can use, and we need to use them. Thank you.
Thank you so much, Leonard Silk. And I'm sure the audience are taking note of where they can find answers to their problems. Let me now ask Mr. Jonage from a practitioner's point of view. Now, the Leonard Silk knows what to do sitting as an arbitrator. Now, you are counsel. Your client is looking to you to help manage dilatory tactics. So how do you what are the practical tips you would offer to our listening audience as to how you can help to curtail those tactics?
Okay, thank you, Victor. I think to start with is where arbitration begins, and it begins at the drafting of the contract. So the arbitration clause or the dispute resolution clause is a very, very important clause that needs to be drafted and to be back to back, leaving no space for doubt. I have experienced some arbitration clauses that in themselves, they elicit a dispute within a dispute in terms of interpretation of what is to be done, what is the next step. My senior has talked about make it conclusive in a way. In terms, many a times, of course, it is party autonomy. You give the parties the chance to agree on appointment. But if they do not, as many a times they will not, then have a default mechanism. Appoint an appointing authority, appoint an institution, a court, or whatever it is, but ensure that back to back, the arbitration clause is very clear in terms of what is the first option. Is it appointment by consent of the parties? In failure to do that, give timelines that within 7 days on default, then the other party can proceed to invite the default in the appointing authority to make the appointment. So it starts from the genesis of the contract. If you have a pathological clause, and a pathological clause in international arbitration is a clause that has a dispute in itself, and it cannot be interpreted and agreed upon by the parties. So if you, as counsel, if I find myself with such a clause, then at that point I would advise my client, it is better we try and invite the other party to agree to a more clear clause so that the process can go on well. Further to that, you have to be grounded in the law and in the procedure of arbitration. That is the only way you'll be able to know how to maneuver these dilatory tactics. If the other party is playing the dilatory tactics, it is upon you to object and guide the tribunal as counsel as to where the laws and where the guidelines, as my senior has put it. CIAB has a lot of guidelines in terms of whichever situation that you will find yourself in the arbitral process, you can find an answer and how to manage the process in the guidelines. So knowledge of the law, proper drafting of the contracts, and basically being very alert in terms of the engagements of the arbitral proceedings will help you be able to pick out and help the tribunal to navigate the maneuvers, because as counsel, you also have that duty to ensure that the process is expedited in every stage. Thank you.
Thank you so much. So basically, vigilance is the price of progress in arbitration. So if you're at the point where you need to apply for an unless order, which we'll get to, apply for it. So just to be vigilant as counsel and know what to do, when to do. Okay. I think Miss Sozo is back. Are you back, Miss Sozo? Okay. So we go on to the second one, which is this. I guess there'll be a bit of overlap, but where you have perennial filing of applications, some of them frivolous, or mostly frivolous, but destructive nonetheless. For example, dubious arbitrator challenges like the Leonard Silk has mentioned, or extensive discovery requests. I have had in my situation a case where there's a perennial application for extension of time to take a procedural step. File your statement of defense. Person waits 1 day to the day. Oh, I need another 10 weeks for it, and all of that. So just to ask again, how do you mitigate that? I will now start from you this time, Njoro, again, go back to the Leonard Silk as an arbitrator.
Okay, thank you for the question. Again, arbitration is always guided by rules and procedure. For example, the CIAB Kenya have very progressive rules that we came up with at the height of COVID. So they are very progressive in terms of even looking at all dynamics and even virtual hearings and all that. The CIAB has also given very many guidelines on this. So the key point is for the council to always be very aware of all the guidelines that have been issued, all the rules of procedure and the applicable laws, and always object to such, know when to call for the tribunal to make the peremptory orders if necessary, and basically be there in a very vigilant manner to guide the tribunal in terms of reference that this is the law, this is the procedure that ought to be adopted, and borrow best practices from across the world. Arbitration is an international scene, and enriching the tribunal with this information will ensure that basically you are helping the tribunal to maneuver and also helping your client to prosecute the matter and have it determined at the shortest time possible. So again, vigilance in terms of knowledge of the law and procedure, in terms of knowledge when to object and how to do it in a very proper manner, and give guidance to the tribunal. Thank you.
Thank you so much. For time, let me say it's the same question, but I'll just tag on one so you can address the two together. So there's that perennial filing of application, and then there's the court gambit, where basically you continue to have recourse. The party continually is in court even before an award is rendered. Any step the arbitrator takes, the party runs to court. What in practical terms can one do, under current law? And if I may add a little to it, as an arbitrator, how are you able to keep yourself from, now having some kind of prejudice against a party that does all of this, So two in one question. Yeah.
Okay, first of all, let me try and take it this way. Now, the first thing is somebody runs to court all the time. Well, I stay cool, calm, and collected because I know what the motive is. And I don't let them frustrate me to the extent that I'm going to say something or do something I'm not supposed to do. I always have at the back of my mind the fundamental principles of arbitration: equality, giving each party the opportunity to ventilate its case. So I make sure I do what I'm supposed to do, because I know that if I do what I'm supposed to do and they get to court, the court will send them back, which is what has always happened in my own case for the few parties I've had who feel that they can venture to court on frivolous reasons. So I keep that in mind. And then I'm aware of my powers under the Act and under the rules. For instance, even when it comes to constitution of the tribunal, the Arbitration and Mediation Act, our new law, makes it clear that the constitution of the arbitral tribunal shall not be hindered by any controversy with respect to the respondent's failure to communicate a response to the written communication requesting arbitration or an incomplete or late response, and shall be finally resolved by the arbitral tribunal. Even jurisdictional questions, the competence rule is there to aid us. We have a lot of discretion through, but even the Act also specifies time limits for doing certain things, which we may extend, but it's also our discretion. I also have the power to wield the costs issue, which will make it very clear to them the implications of their actions. So these are all regulations that have been, well, I'll say laws, at times hard law in the laws or soft laws, which have been put in place by several institutions to avoid this type of behaviors. What was the second question? I think it was 2 in 1.
Yes, it was so they've gone to court, and then some of them eventually get a court injunction purporting to stop.
Yeah.
So how do you handle that?
Yeah. Thank you very much. Thank you very much. If they get a court injunction, I'm obliged to comply with that injunction. So I will comply and I will wait. Like the example I gave you, I told you that they initially got a court injunction, and then the court judgment came out and mentioned that they phrased all kinds of frivolous false allegations against this arbitrator and told them go back to that arbitrator. So if there's an injunction, I will stop. But if there's no injunction, I will continue my task. That is simply the answer. I cannot stop them. Everybody has the right to go to court if they want to. But if a legal practitioner really respects the ethics of the profession, such a legal practitioner will not have gone to court in the first place on such a flimsy reason. The legal practitioner's obligation is not to the party, but to assist the court. And it's the same thing in the arbitral tribunal. So we legal practitioners, we have a lot to, our role is extensive. When parties know that they cannot use us when they have bad cases, when we can encourage parties that go and sit down with the other party and try and reason it out. Look, these are the strengths and weaknesses of your case. Let them know that you are not going to be used as an instrument in anybody's hand. Parties will start behaving better. But when we legal practitioners are complicit in what's going on, we will not only damage our reputation, we also damage the reputation of our country, which is just not good enough.
Thank you so much, Nancy. I will check with Mr. John again. Then I'll still come back to this court issue. I can already see a question that's been asked, and there's it may be controversial, but there is a point I want to throw into the room. But first, let's hear from Mr. John again. In Kenya, in your experience, can courts intervene, like injunct pending arbitral proceedings? You're not at the award stage, just say stop proceedings. Is it something you see in your experience doing arbitration there?
Thank you. Yes, of course, we have counsel who will try and stretch the law, even when the law is very clear. Because our Section 10 of the Arbitration Act is very clear. And it states that other than the minimal interventions that the court has been expressly granted, courts are not supposed to interfere with arbitration proceedings. And the minimal interventions is, for example, Section 6 and 7, when you're seeking for interim orders, you can go and seek the conservatory orders in court and then come back and proceed. And then the issue of appointment under Section 12, the issue of challenge under Section 17 after competence has been exhausted, and then now post-award, which is now the enforcement, the challenge under Section 35 and 36. So do still counsel and court find themselves with such challenges? Yes, they do. There are very many applications that are made to stop arbitral proceedings for one reason or another. But as I stated earlier, we are very lucky to have a very vigilant bench that is well versed in matters arbitration. We have taken a very intentional and deliberate effort as the Chartered Institute to ensure that our judiciary is well capacitated in terms of arbitral proceedings, to ensure that they are not seen as competing with arbitration, but are only used to complement arbitration. And by and large, even the Supreme Court, I am happy to state that the Supreme Court judges of Kenya, all of them are fellows of the Chartered Institute of Arbitrators. So this has helped because the jurisprudence that is streaming right from above is very, very arbitral friendly. Just to quote one case, the new to Agrovet case, which basically stated the minimal interventions that the court allowed are as stated in the Arbitration Act. So that has helped a lot in terms of curbing these frivolous applications that go to court. And anyway, when they go to court, sometimes interim relief is granted, but once the matter is finally heard, because it comes under miscellaneous, so it's sort of expedited. And there's law reform that we are proposing, that we have a dedicated arm of the judiciary to handle arbitral matters, so that we can ensure that it is well capacitated and they can handle because there can be questions which are very straightforward, but when it gets to the court, it gets into the clogged system and you can end up delaying a lot of time. So there are law reforms in this area that we are proposing, a dedicated arbitral court so that it can be listening to all these matters and ensure that they are sent back. So yes, they are there, but we are happy that our courts are well trained and capacitated to handle and ensure that the arbitral process is led to go to its full conclusion. Thank you.
Thank you so much. Now that's controversial point I'm going to make, and then we'll just have about 5 minutes before Q&A. I think Mr. Nobongozo is back. Now, when Nigeria, we have these provisions in the Arbitration and Mediation Act. One that says that even when you are challenging an arbitrator and you're even in court, to determine that challenge, that arbitration can continue, including with the challenged arbitrator, and can go all the way to an award stage. That's one for frivolous arbitrator challenges. There's another one that also says, and I think this is patterned after the model law, that courts shall not intervene in arbitration except as provided in the Act. Right. So my question, I'm going to put it, I understand sensitivities about do you want to not comply with an injunction, even if you know that that injunction is not valid? So I think Ms. Soza is back. While the practitioners think about it, let me ask it in as controversial a manner as possible. Ms. Soza, as in-house counsel, let's say you have $5 billion project being held up by arbitration that is going on forever because of dilatory tactics. Would you be comfortable if your arbitrators relying on these provisions say, despite the court gambit, what is in court is not something that the court is permitted by the Act to be injuncted. Therefore, we are willing to continue the arbitration. Would you, as client, would you be comfortable with doing that, knowing that that's actually what the law provides?
Thank you. I hope you can hear me.
Yes,
yes,
we can now.
Yes, I would. In fact, we encountered such a thing in an arbitration 2009, 2010, where a third party went and got an injunction and restrained arbitration. So this third party was not even part of the arbitral proceedings at all. Luckily, we had gone, how do I put it, almost 2/3 of the way. And the arbitral tribunal, they were not injuncted. They were not part of the court case. So they said they're going ahead and they issued a partial award to us, whilst we, the parties, were restrained by the Nigerian courts from continuing with the arbitration. But we took that benefit. So frankly, unless we are expressly restrained from continuing to participate in the arbitration, which was the case there, we wouldn't, if there's no restraining order, we will go ahead as long as the tribunal is willing to go ahead in line with the new Arbitration and Mediation Act that we have now in Nigeria.
Okay.
Yes, please.
Thank you. Then let me flip to the Leonard Silk. She's a member of the Inner Bar,
Yes.
and I'll be very much interested in knowing her thoughts if this were to happen.
Well, if this was to happen, we have to look at what the law says and interpret it in the light of the law. Of course, we know that there's the principle that was in the old ACCA, I think section 34 in the old ACCA and section 67 or 68 in the new MA, that a court shall not intervene in any arbitration matter unless as provided under the provisions of the Act. So we have to go according to what the law says. But we have to look at every significant circumstance. I liked it when Ms. Ozo said that in that case, the arbitral tribunal was not injuncted. It was the parties. So we have to study it. And I think I would not want to say something in isolation of actual facts. So we have to look at the facts and make sure that it ties in with the provisions of the Act to make sure that we're in good order. Another thing that's also good now in Nigeria is that we have the arbitration claims procedures that's attached to AMA that talks about the way to make your arbitration claims and all that. Another good thing coming from Nigeria is that under the new national policy, there have been a lot of talk about the time factor. When you have an award and you want to enforce and they start at the High Court, they go to the Court of Appeal, they go to Supreme Court. And the time factor has been held to go on for as long as 5 years. In the IPCO case, I think the judge in that, the English judge said something about 30 years. He's not sure the matter will be heard. But I think the arbitration community has taken proactive steps because under the new national policy, I'm still waiting to see how it's going to be implemented by the various sets of courts. There are timelines now for matters, for timelines for the duration and arbitration matter is supposed to stay in the High Court, in the Court of Appeal. So these are all new innovations that are coming out that should really assist the arbitration landscape. But as to regards your question, we have to know the circumstances, we have to know the wording of those injunctions, because at the same time, we still have to respect our courts. And that's why we keep on saying, we keep on being very happy when, like it was mentioned that in Kenya, a lot of judges are now members of the Kenyan branch of the Chartered Institute. That's the same case in Nigeria. We've seen a lot of good judgments coming out of Nigeria now with respect to arbitration, because a lot of judges now understand it. And even where they don't understand it initially at the lower court, the upper courts do the needful. They remedy the situation in most circumstances. So we have to keep respecting our courts, but respect them also within the law. And even if they've done something that is not appropriate, the appropriate action is to appeal. It's not to write a frivolous petition. I've never been one for writing petitions against judges. There's an appropriate procedure. In fact, most times when people write petitions, it's to intimidate. So if we are doing that as well, then we might as well be as bad as the people who are engaging in dilatory tactics. Thank you.
Okay. Thank you so much. I just want to thank you because now we are the press for time, so we are going to the questions, but I want to thank each and every one of you and to thank this audience. We have over 500 persons who joined for giving us this time. So I have questions on the screen, which, were foreseeable. So I have a question in no particular order. I'm just going to make this pop out. But basically the person is asking, so if we have to go to if we still have to go to court to basically make the arbitral process work, why should we bother going to arbitration at all in the first place? So it's open mic for speakers. Anyone can just take it up. So is it still worth it?
Well,
yeah.
All over the world, the courts are recognized as partners in the process of arbitration. Arbitration cannot stand on its own leg alone. It needs the support of the court system. So the issue is for us to stop all the bad behavior that we may have when it comes to using the court system in an unfair and in an appropriate manner. But we still have to go to court all over the world. Even in England, they have to go to court in some instances, even where it's an arbitration proceeding. An arbitration cannot stand on its own. You still need the support of the court system. And that is why, even in the Act, it's written there, the instances when the court can intervene. And then there's that special injunction that no court shall intervene except as provided under the provisions of the Act. If you want to set aside an award, there's specific circumstances under which you can set it aside. If you want to enforce an award, and arbitration is not self-regulatory. Arbitration does not have the state police like the court system. If you want to enforce, you still have to enforce through the British state of nature, I think. So we just have to keep on praying and working hard. Nigerians, I know we like to pray a lot, but aside from praying, we have to work hard at improving the system and getting our lawyers to do the right thing. Go to court only when you have to go to court. Don't go to court at the whims and caprice of a party. Don't intentionally try to frustrate the arbitration proceedings. It's not projecting us in the proper light, but we still need the court system as they need all over the world. England is popular as a seat of arbitration because they have supportive courts. Singapore, within a very relatively short time, became popular because of the support of the court system and their arbitration laws. And Nigeria is not lagging too far behind. We have a good arbitration law now. We can still improve. There's nothing that cannot be improved.
Thank you so much. So, Ms. Njoroge, this one was asked, it was made like a comment, but I'll ask it like a question. So it says, even parties essentially having recourse against the award. So you have an award, parties going to court to set aside or something, that in itself is also dilatory tactics because it prevents the award creditor from reaping the benefit of the award. Do you agree with that notion, whether qualified or unqualified?
Okay, thank you. I think post-arbitration, the law is very clear in terms of the court's intervention. And one of them, as my senior said, we cannot do away with courts and arbitration. We are joined by the hip because especially of its enforcement mechanism. So once an arbitration is done and the award is rendered, you'll have to go to court for recognition and enforcement. So that is the complementarity spirit that we advocate for to help arbitration process. The question of challenge of the award itself, it's also provided for under the law. Because remember, also the law, the High Court, like in Kenya, it has, the Constitution says that the High Court has supervisory jurisdiction of tribunals, including the arbitral tribunals. So if you feel that there is something that has been, the determination has been made outside the terms of reference and the agreement between the parties, then you have the right to challenge that. But remember, the provision under that challenge is very narrow, and you have to fit in within, like for example, if it is issues of impartiality, if the arbitrator has usurped his power, has gone over beyond what was expected of him. So there is that control mechanism that is provided. So the court is there to ensure that the arbitral process is guided and lives, one, by the agreement of the parties and by the laws and rules that are applicable to it. So it is an option that is available. I have had my awards being challenged, luckily none successfully, because it is the right of the parties to challenge. And if the challenge is not successful, then the fruits of the award shall then follow. Thank you.
Thank you so much. Thank you. Just because you're pressed for time, I'll just proceed to just take any final comments from Ms. Ozo. Just any final comments so that we wrap up. But thank you so much for all the contributions. Yeah.
Thank you. So arbitration is an improvement on litigation, I would say. There's so much to be gained in terms of the expertise of the people that you get to choose to be your arbiter, you know, to try a matter. And then the whole comfort and everything around is supposed to make it go as quickly as possible. I want to encourage us all, please, especially the practitioners, the external lawyers who practice, to try and stick to the rules and make it work. For many people, when you come to arbitration, you choose it for your dispute resolution. At the back of one's mind is really that we will stick with the outcome. So please, let's make it as robust as possible, and let's not import in these dilatory tactics and conducts in the guise of procedural robustness on behalf of our clients to come and derail things. And there's something I want to add. I'm thinking that even from litigation practice, where if you file a frivolous application, you lose, cost is awarded, and they say you get to pay before the next adjourned date or before you're ahead. I think that's something we need to also look into introducing, whether it's in the arbitration rules or at the outset or something. That way people will also stop filing, you know, frivolous things and allow the process work. Thank you all so much for attending and listening.
Thank you so much. Ms. Njoroge?
Yes, thank you. It has been a pleasure participating and getting to learn a lot from the Nigerian jurisdiction. My final remarks would be arbitration is the future. ADR is the future, and we need to support all the alternatives to court to ensure that the advantages that comes with it, the privacy, the confidentiality, the cost effectiveness are actually realized by the parties. It is a party-driven autonomous procedure that ought to deliver justice in an expedited manner. So bringing in the dilatory tactics can really water down this aspect, and it would also send out a very bad word to the African, as the African continent, we are not safe seats. We are at a space whereby everyone is looking into Africa, and we need to make our seats to be very safe in terms of arbitration. We need to make our foreign investors to have confidence that they can come here. They can. We have international arbitrators in Africa who can be able to be very neutral, independent, and fair in terms of adjudicating upon their international disputes. And this can only be supported by even counsel and all parties shaking away these sideshows of dilatory tactics and ensuring that arbitration lives to its glory. Otherwise, I thank you very much, and it was a pleasure participating.
Thank you so much. And Leonard, still last but not least, you.
Thank you very much for organizing this webinar. I want to say that, like we can see, arbitration and litigation should be partners in progress. They are two instruments that cannot do without the other. Litigation, it needs arbitration to decongest the court system. We see how our courts are so congested. We should give our judges some leeway to focus on more serious issues rather than frivolous applications. And this is not to say that I am saying that parties should not go to the courts when they have to. I've had to apply for an award to be set aside in parts once because the arbitrator did, in our view, did something untoward. The point on the matter that we went to court for was that there's a part of the award where the arbitrator did not listen to the parties never raised it, and the arbitrator went and made a vital decision on that basis, which deprived the claimant that I was representing at that time a big portion of the cost it had been awarded for because it did win on the merits. And we had to go to the court. That case went all the way to the Supreme Court, and it was upheld that the arbitrator should not have raised a matter suo motu. I'm sure we all know that principle. You cannot raise a matter suo motu, a matter that was not raised by the parties, and then on your own, go on your own voyage and make a decision on that point without putting it to the parties. I mean, that's growing our law, that's developing our jurisprudence. So we do appreciate the need for some matters that will need to go to the courts, like in all other jurisdictions. But the issue is that we should not bring frivolous applications. I liked it when Mrs. Ozo mentioned that arbitration is more comfortable because when you go in for arbitration, you know the time the proceedings is starting. So you don't have to go to court and be waiting your time or waiting your turn. You know when it's starting, you are in comfortable surroundings. Well, I know the courts are also comfortable. So I'm not saying the courts are not comfortable. But for so many reasons, arbitration is the preferred option for resolving business disputes. And we should please strive to ensure that we do not become wheels in the clog of progress. Thank you very much for having me. I really enjoyed myself here.
Thank you so much. Thank you so much, all our speakers. I know we are virtual, but audience, I think our speakers deserve some virtual applause. So thank you so much, our speakers. So just to thank you to the audience for staying with us. We know it took some time, and I know there are questions we couldn't take. We apologize for that. Regarding the CPD, if you filled your form properly, you would get your the CPD points. And of course, the recording of the session will also be shared. I want to thank the CRAB, the Executive Committee of the CRAB Nigeria. I also want to thank even CRAB Kenya for lending us, Mr. Njoroge. I thank the Leonard Silk for making time. I couldn't have paid you if I were to otherwise hire you. I want to thank Mr. Nobongo also too for making time out of your busy schedule. Thank you so much, and please keep attending our programs. And also, if you have areas that you think you'd like us to discuss, we invite you to just interact, engage, and let's keep the conversation going and make arbitration better. So thank you so much, and enjoy the rest of your afternoon.
Thank you.
Thank you. Thank you.
Thank
Bye-bye.
you. Thank you.
Thank you.
Thank you.